the third unit exam. When?
Monday.
Monday. Here we go. What chapters? Okay, chapters 26 and 27 on agency law, and 31 through 36 on the different forms of business ownership. So we technically have only 2 topics. Please remember your Scantron answer sheet and your number 2 pencil. Also, if you're unable to meet your commitment to be here for the test with your classmates on Monday, may I be the first to know so we can reschedule something for your benefit. Time will go rather rapidly on that particular day. Hopefully I feel better now. Grandma's here. Hate when somebody has never missed the whole time and then they miss the last day. You're here. Thank you. Time will go rather fast, and if I don't hear from you, I'll do final grades and you'll be left out. And I don't want that to happen to you. So communicate if there's a problem. And we'll work out something. The third test will be just slightly different. No, there will not be 80 questions like the other 2. There will be 90. Why? Because I couldn't find 10 to get rid of. They were also good. It'll take you probably less time, however, to take the exam because all the questions are true false on this last one. So you won't have any trouble reading the question. That's for sure. And I will be here during the test, so don't worry about that part. Okay, here we go. Again, 2 topics, agency law and the different forms of what I call business ownership. Speaking about agency law, we can have a general agent and we can have a special agent. Special agents only do one type of thing for somebody as opposed to everything. General agents, of course, do anything for somebody. We talked about, and I put it right here, a principal, an agent, and a third party. Principal is somebody who wants to do something, but they don't want to do it themselves. I didn't say that quite right. They wanted something done, but they didn't want to do it themselves. So they get an agent to do it for them. Remember, any of these entities here could be an individual, a partnership, or a corporation. We typically talk about people, but it could be any of these over here. The purpose is for the agent to facilitate a binding contract between these 2 parties. Know what is meant by ratification by a principal. What does it mean to ratify? One more time, simply to approve. Can the principal approve something they're not bound in? Yes, they can. They don't have to by law, but if they do, they totally forgive the person or entity that created the problem because they're not obligated, but they can choose to be obligated. They can ratify the contract. It's a serious form of forgiveness. They therefore cannot sue this individual. They have to pay the individual as if they asked them to do something. And then the principal is bound by law. What I didn't say in class was that the entire act must be approved. In other words, if they're going to ratify something that they don't have to do, I should say here, if they're going to ratify this, they have to approve all of it or none of it. All or none, not just parts. Know the difference between an employee and an independent contractor? They're both considered to be agents. All things that one has a right to do personally may be done through an agent. True or false? True. Nope, that's false. Remember, that's one of the ones I really like. Notice. Notice. All things that one must has a right to do personally, may be done through an agent. No, you have to show up for the test on Monday. You can't send someone else. And thus, I gave you a lot of other examples: to vote, to be a witness, to execute your own will. You cannot have an agent do that for you. A minor contract is usually voidable. True or false?
True.
True. A principal must be competent. True or false?
True. False.
True. Remember what's going on here? You're going to be in a binding contract. And what's one of the essentials of a binding contract? A valid contract? Capacity. So therefore, principal must be competent. An agent usually needs capacity. True or false?
True.
This is a tough one. Logic is not on your side. The answer is false. An agent usually does not need capacity. Why? Because notice here, there's no binding. Trouble is, in chapter 27, we have three types of principles. And these two, the agent was bound by law. So therefore, it would seem that the agent would most likely need capacity most of the time, because it's needed in 2 out of 3 situations. But why is that false? Because this is the most common. These are unusual by comparison. They're sort of infrequent comparatively. So typically the agent does not need capacity here, because they're not going to be bound. They're not making any promises of their own. By the way, can they choose to be bound?
Yes.
Even though by law they're not.
Yes,
They may. Then they are bound. Can an agent be authorized to commit a crime?
No.
Remember also that an agent cannot compete with their own principal. Know what is meant by a fiduciary duty. One of my favorite concepts. Remember, the interest of the principal must come first, and the agent must disclose any information that they come across. They must disclose it to the principal. If an agent acts in bad faith, can they be discharged or fired?
Yeah.
Yes.
Yep. Can they be sued?
Yes.
Yes.
They can. Can agents automatically delegate to a sub-agent? No. The principal has really hired most of the time this agent. They didn't hire anybody else, a sub-agent. Now, agents can have sub-agents, but they need permission from the principal. What are some exceptions? Something that's clerical, then the agent can delegate that to someone else. And probably another exception is when it's customary. All agents of that type delegate some of the work to someone else. An agent can be personally liable for a wrong while acting for a principal. True or false?
Yeah. True.
True. If they're wrong, they're wrong. The bankruptcy of a principal terminates an agency. True or false? True. Know what is meant by the commingling of funds. It is illegal. If an agency agreement does not specify compensation, is there any? And the theory is yes. You probably would never want an agreement without knowing what the pay is, but some people are not very detailed. Keep in mind also that this relationship right here does not have to be contractual, which means that it does not have to be any kind of promises made particularly. Which means what? somebody may get into what's called a gratuitous agency. Somebody is gonna do it gratis, do it what? Free. They're not going to be paid. That's a possibility also. Not as common, but possible. The principal has the right and the power to terminate at any time. True or false?
True.
One more time. The principal has the right and the power to terminate at any time. Of course, means terminate the agent.
I thought it could.
True.
I love the mumbling. Yeah. One of my favorite concepts. Remember, I put it over here. The power versus the right to do something. And what did I just say? I included both of them, didn't I?
Yeah.
The principal has the right and the power to terminate at any time. That's false. They always have the power, but they may or may not have had the right. They might be sued, but they have the power. They can terminate at any time. And if they terminate somebody, they are gone by law. Keep in mind that an agent cannot expect to be paid extra for information. Why? Because they have a duty to inform already, part of their fiduciary duty. Who is liable if an agent is negligent and injures the property of a third party? Is the principal liable? Yep. Is the agent liable? Yes, as I like to say, because they did it, right? So they're liable, but so is the principal. We moved on to chapters 31 through 36. This is not a trick question. How many people can own a sole proprietorship?
One.
One. You know what I found over time? That many times that has not sunk in for some people. Why? I don't know. It's a form of business ownership, but you know, it's still one. No matter what. Look over the different types of partners. General partner. Remember, anytime the word partnership is used, it means a general partner unless otherwise specified. So we have a general partner. We also have a silent partner. We also have a secret partner. We also have a dormant partner. We also have a nominal partner. And finally, we have a limited partner. Anytime a general partner leaves the partnership for any reason, the partnership dies. As we learned in the final chapters, it dissolves. A partnership must be for profit. True or false? True. You cannot have a not-for-profit or non-profit partnership. Anything that is non-profit or not-for-profit must be a corporate form of business ownership. Keep in mind that a corporation is a legal entity separate from its owners. And it's incorporated, of course, by state. How does your book say to start how does your book say to start a sole proprietorship? Just begin. No particular formalities. That's basically true. Keep in mind, I keep saying there's why an exception to everything. Try not to read exceptions into a question unless it's clear that the question is about exceptions. You might have to have a sales tax license. You might have to have a certain certification as an MD to do surgery and things like that. But other than that, you can just begin. By the way, you could basically end the same way, assuming you've proven to the IRS you paid them any taxes that would be owed. Certainly know the difference between limited and unlimited liability. A very serious issue in law. also know which of the basic ones that we covered in terms of forms of business ownership are tax favorable and which are tax unfavorable. Partnerships must be for a lawful purpose, true or false?
True.
True. It's the old story. Can't complain that I didn't mention it, but I mentioned it, so therefore I mentioned it. Must be for a lawful purpose. Because once I had a student say, well, you didn't say it had to be for a lawful purpose. So I'm saying it. How's that? The death of one partner dissolves a partnership.
True.
True. Same statement, said a different way. Who controls a corporation? Your book likes to say the majority of the voting stock. And what's that? Of course, we know the common stock. A minor can't be a partner, true or false? False. They can be a partner. But what kind of a contract or agreement are they getting into? Avoidable one. Therefore, they can disaffirm or whatever, leave at any time. What's the difference? In this case, they must pay their share of the debt. But they cannot be penalized for breaking their promise, so to speak, and leaving. Can a corporation sue?
Oh, yeah.
Yes. Can it be sued?
Yes.
Yep. I may not have mentioned this one. Mark that. Sometimes courts will ignore what's called the corporate entity. It is called piercing the corporate veil. In other words, if it looks like a duck, it quacks like a duck, it better be a duck. But you know, if you pretend you're a corporation and you don't follow all the rules, you can be sued, and the government can come after you. And the courts can pierce the corporate veil, and you will be relegated to what? Unlimited liability instead of that protection of limited liability. Be treated more like a partnership than a corporation. Partnership agreements must be written, true or false? Partnership agreements must be written. That's false. Partnership agreements can be the slightest of formality or the greatest. Articles of partnership usually state how profits and losses will be shared, true or false?
True.
True. That's one of the main purposes of having an agreement. Partnerships cannot exist unless the parties call their relationship a partnership, true or false? One more time. Partnerships cannot exist unless the parties call their relationship a partnership. Glad this is a review. No, that's false. Remember, we can have a partnership by estoppel, can't we? If somebody says they're your partner, you don't stop them, they may become your partner by estoppel. If somebody relies on that promise, remember, a promise relied upon. So you don't even want it to be a partnership, but the court may rule you as being a partnership because of your behavior. And another one is if you're caught with what's called prima facie evidence, that's called real definite evidence, you're caught sharing profits. Even though you don't intend to have yourself as a partner, you may be ruled as a partner because you're caught sharing profits. And I like to throw in, you're caught sharing losses maybe. Many businesses don't make a profit the first couple of years. Remember also, we had over here what we call partnership property. Remember that? A business asset. The general partners have an interest in the partnership property. Sometimes called specific partnership property. Either is fine. They all at the same time have an interest in the partnership. Profits and capital. That's a personal asset. Remember also, I don't know that I mentioned it, partners cannot have secret profits. Any profits they earn being a partner belong to the partnership, not to the partner personally. Do partners have a fiduciary duty to one another?
Yes.
Absolutely. Do partners have a fiduciary duty to the partnership itself?
Yes.
Same thing, yes. Keep in mind, a majority decision controls partnerships for ordinary contracts. Most all decisions are by a majority vote. However, if we change the character or conditions of the partnership, that vote must be unanimous. If we change how we share profits and losses, if we change how long we're gonna be partners, that must take a unanimous vote. If one partner out of two cannot pay, the other one must pay all of it to a vote.
True.
That's true under joint and several. So if we have just two partners and one partner doesn't have any money and there's unlimited liability, the other person must pay all of it. That's part of being several. Jointly they owe it all, the two of them together, but each one separately owes it all. If you have to pay more than you were supposed to according to your agreement, you can sue the other party for the difference. It's called a right of contribution, a right to sue your partner for what they didn't pay when they should have. But by law, you've got to pay all of it if they get your personal assets. Know what is meant by contributions? I put it right over here, which you might put into a partnership to start a partnership. That's called your capital contribution. Sometimes just called contribution. The next question is then, can you withdraw your contribution at any time? No. There are only two times. Once during the life of the partnership, when you request to have all or part of your contribution back for personal reasons. And it's up to the partnership as to whether they're going to do that or not. The other time is when a partnership is dying, when it's terminating, when it's ending, dissolving. Then they can ask for their money back if the partnership is what? Solvent. What does that mean? We have more money than we have debt. If it's insolvent, it's a moot point. There's nothing to ask for because there's no money left. If you get your contribution back, you're not entitled to interest, but it can be awarded if the partners agree. Can a partnership be held liable for the torts committed by a partner?
Yeah.
Yep. Who's liable? The one who committed the tort, as well as then the partnership. What if the partner doing partnership business commits a crime? Who's liable?
Both of them. Both.
Both. The one who did it, and then also the partnership is liable for the crime if it's committed by a partner doing partnership business. Remember the exception, however, to that one. Innocent parties cannot be punished. And then you're into a situation where you may have to prove your innocence because you look awfully guilty. But if you can show you didn't know, you weren't a part of it, you had no idea, innocent parties cannot be punished. But as general in life, you can't just claim that, you have to somehow substantiate it. If not stated, how are profits and losses divided in a partnership? Equally. Know what is meant by an incoming partner. Somebody new. If somebody jumps in and becomes a new partner, are they liable for any debts created before their arrival?
No.
Yes.
Oh.
It's called limited liability. Limited to what? The incoming partner's contributions, because they're going to be asked to put something in the coffers here also, just like the original partners were required to put some contributions in. The incoming partner is going to be required likewise. So it's limited to their capital contribution. After their arrival, then they have, of course, unlimited liability as a general partner. Is there a prescribed form for forming a partnership? No. In my opinion, that's a good reason to get legal counsel so you don't miss something, because there's no form where you fill in the blanks, at least typically. This may be overly simplistic, but please keep in mind that not all violations by a partner justify seeking dissolution. Sometimes people make mistakes, they mess up, they do something wrong. It doesn't mean you can kick them out. Sometimes, yes, but many times, no. It was not serious enough. If one partner failed to use adequate care and skill, must he or she reimburse for the loss? Yep, because they were negligent. Otherwise, if you work as hard as you can and mess up, you can't really be punished. As I keep saying, stupidity is not a crime, or people make mistakes. As long as they're working about as hard as they could, you can't be right all the time. Make the perfect decision every time. Know what it means to operate or be part of a partnership for no definite term. I didn't mention that during class. I don't know why. I just didn't. Another reason for review. A partnership for no definite term. What does that mean? We don't have a time frame on it. That's all. So it means you can leave at any time without penalty because you didn't breach. You didn't violate the conditions because of time. However, if there is a definite time frame, like 3 years, and you leave at the end of 2, oops, that's a wrongful withdrawal as opposed to a permitted withdrawal. And you can be punished for that. A partner has the power to withdraw at any time, even if it breaches the partnership agreement. True or false? One more time. A partner has the power to withdraw at any time, even if it breaches the partnership agreement.
True.
True. They have that power. They may or may not have had a right to do so, remember? They might be sued, but they have the power to leave at any time. And remember, if they leave, it dissolves the partnership. The bankruptcy of a partnership causes dissolution. True or false? True. Keep in mind what dilution means. Sort of falling apart, dissolving, if you will, dying. Ending. The bankruptcy of a partner causes dissolution.
False.
True. Remember, anytime a general partner leaves. Anytime a general partner leaves. We had dissolution in 3 categories. We have had over here by the acts of the parties, sometimes called actions of the parties. I prefer acts of the parties. We had a court decree, and we had operation of law. Notice of dissolution must be given when it's by the acts of the parties that it's caused. The other 2 do not require any notification. Over here, if it's by the acts of the parties, actual notice must be given to those with whom we're doing business currently or have done in the past. For anyone else we don't even know about, constructive notice must be given. In other words, the equivalent of public notice, an ad in the paper, if you will. A notice at in a trade magazine, something. Partners may decide that one of the partners lacks capacity. True or false? Partners may decide if one of the partners lacks capacity.
False.
Remember that basic one? The answer is false. Takes a court decree, thank you. Right in the middle here. Remember I said that one day Dick, Harry, Mary might think that Tom's crazy or a loon? But they can't just kick him out because they think so. They must get a court order. Because you see, Tom may be the only sane person in that bunch. You never know. Can somebody purchase a partner's interest in the partnership? That personal asset? Can somebody purchase a partner's interest in the partnership? Yeah, it's called an assignment. If it's a personal asset, you can sell it. You can assign it to someone else. Thus, it's called an assignment. Does that person who bought that interest become a partner? No. By law, the partners cannot be forced to take on partners they don't approve of. Under the concept of what? Delectus persona. You have a right to pick your partners. Keep in mind, somebody who has bought a partner's interest in the partnership has a right to the capital and profits, but no right to manage, and thus no right to be a partner, by law at least. The existing partners can decide to make them a partner, but not by law. Also, if Tom assigns his interest in the partnership to someone else, it does not mean that he is gone as a partner. So there's no dissolution. He just doesn't get his money anymore like he used to. He sold it. Somebody else gets it now. Losses in a partnership are normally shared equally, true or false?
False.
No, it's true. Normally equally. If the date of the dissolution of a partnership is changed, the vote must be unanimous, true or false? True. Remember we had that one? Any change in the character of the partnership, it must be a unanimous vote. Also keep in mind that the temporary inability of a partner to perform duties does not justify dissolution. It must be permanent, so to speak, not temporary. Dissolution prevents the performance of existing contracts, true or false? No, that's false. I remember, if past this point in time, the partnership starts to dissolve, any promises made here in the contract must be kept from the past. A promise is a promise. And if they don't keep that promise, they can be sued for breach, even though they're dissolving. Once they start to dissolve, can there be new contracts?
No.
Yes, yes. Because to wind up or liquidate, they may have to hire a company to do so for them. That's a new contract. And it's joint and several, and it's unlimited liability until final termination here. Or if Tom dies, the partnership dissolves, but Dick, Harry, and Mary may want to continue on. So they're not going to go past dissolution. They're not going to get involved in winding up. They're not going to sell everything off and convert it to cash. They want to continue on. And often that agreement is there from the very beginning when they first agreed to be partners. That any remaining partners can continue on if they so choose. Know what it means to dissolve or futility. One of my favorites. If things are futile, they're hopeless. So therefore, somebody may take you to court, and if they can prove to the courts that your company cannot make another dollar of profit, the courts will dissolve the partnership for futility. And then it is over. Thus, a court order, if you will. Know what is meant by an S corp, an S corporation. Profits and losses of an S corp are personally taxed. There is no double taxation. That's the exception to corporations and their advantages and disadvantages. They're treated like a partnership when it comes to reporting income. Taxed only once. Keep in mind that corporations are incorporated by state, But can they do business anywhere?
Yeah.
Yes, they may. Know what is meant by an ultra virus act. That's when a board of directors exceeds its lawful powers as a board, and they can be held liable for exceeding those powers. The book makes it clear that it's not likely to happen today, because they can do anything as a board that will benefit the corporation, even if it seems strange. They can make any kind of a purchase or sell something if it'll benefit the corporation. The death of a major stockholder in a corporation dissolves a corporation. True or false?
False.
False. Remember, owners can come and go. Does not affect the life. Does not affect what we call the continuity of the life of a partnership. We have what we call, as an advantage, perpetual life. Owners can come and go forever unless we just have the corporation die. Is an ultra virus contract binding between the corporation and the other party?
Yeah.
Yep. Even though they exceeded their authority, the corporation is liable for that behavior. That's why a board can be punished for so doing. Corporations are only for large businesses. True or false?
False.
False. It can be large or small. Most are small. Most corporations have double taxation. True or false?
True.
True. It's considered to be true, even though we have the exception of an S corp. Can a corporation be sued in the corporate name?
Yep.
Yep, it's considered to be a legal entity in the state in which it's incorporated. Now, what is meant by a dividend? That's how a corporation shares its profits, by declaring a dividend to its owners. Then the owners must report that as personal income. A stockholder has a right to manage. True or false?
False.
False. It's one of the rights of a partner, but not one of the rights of a stockholder. Know what is meant by a quorum. Your book likes to say it's usually a majority of the common stock. That's a quorum. It means then, therefore, you can conduct official business. Why? Because somebody can have a winning vote. And who is that? Somebody who has 51% of the vote. And by the way, that can be substantiated in person or by a proxy or combination thereof. What's a proxy? An absentee vote. Proxy. By whom is the board of directors elected?
Voting stockholders.
Yes, voting stockholders, and we call them common stockholders. That's correct. I didn't mention this in class, but do corporations have to have stockholders meetings?
Yes.
Yes, that's part of what looking like a duck and quacking like a duck. You must do that. See, if you're a corporate form of business ownership, there are rules you must follow. And if you don't, you may not be recognized, and the courts may pierce the corporate veil. By the way, if you go to a good corporate attorney and they have it all finalized and everybody signs and all that stuff, the attorney will typically have a copy of for each of you, copies of the minutes of your first meeting that you never had, to get the legal ball rolling, to substantiate formality. Who selects or hires the corporate officers or executives?
That would be the board of directors.
Board of directors. Okay, the board selects the corporate officers. Upon the dissolution of a corporation, remember, not a partnership, but upon the dissolution of a corporation, stockholders must pay for any losses. True or false?
False.
False. Remember, one of the advantages of a corporation is limited liability. Limited to what? Your investment. The amount you paid for stock, your investment. You can't lose any more. If you bought $10,000 worth of stock and the corporation loses $82 million, you can't lose any more than your 10 grand. Unless, of course, that corporate veil is pierced. But otherwise, no. That's one of the big advantages of that form of business ownership. If you really care, the third exam will be printed on pink paper. If you don't care, it'll still be